OK。はい、では時間になりましたので始めたいと思います。皆さんこんにちは。このセミナーは、各週火曜日のランチタイムにお届けしている米国特許セミナーExaminIrksです。講師はブライアン・エプスタインさんです。そして今回は特別ゲストとして、元 USPTO 審査官である、ディバン・タコールさんにも参加していただきます。タコールさんのプロフィールを簡単にご紹介しますと、UCLA で博士号を取得後、ハーバードメディカルスクールや京都大学などで再生医療などの研究に従事されました。また、2011年から今年の1月まで約10年間にわたり USPTO の審査官を務められました。また、日本語が大変ご堪能ですので、ここで、日本語で少し自己紹介をしていただきたいと思います。Dr. Tako, thanks for joining us. Would you introduce a little bit of yourself in Japanese, if you don't mind?
はい。Thank you for the introduction, 大島さん。出番です。出番の出番です。今日も。今日はありがとうございます。自己紹介っていうのは、大島さんが多分大体全部、僕の人生はそんな感じですね。UCLA で、博士、PhD 取りました。で、それから研究者として京都大学の再生医療研究所にいて、で、研究しました。で、それからハーバードで研究しました。再生医療の研究。で、それから USPTO に入りました。で、Art Unit 1619に入りました。Technology Center 1600が、医療ですね。一応、薬院じゃない。ファーマシュティカルと、一応、そうだね。ファーマシュティカルとか、そういうことで、今月、特許庁を辞めました。はい。よろしくお願いします。
はい。ありがとうございます。今日はよろしくお願いします。今回、タコールさんの、審査官経験者としての貴重なご意見を聞ける回となっています。今回のテーマは法律を知るとなっています。前回は審査官は法律に精通している人ばかりではないということを解説いただきました。今回は審査官と違って、代理人は法律に精通していなければならないということを具体的に解説いただきます。それではお話しいただきたいと思います。Okay, Brian-san, during our last session, we discussed how examiners are not expected to know the law. Can you discuss more about who should or should not know the law?
Yeah, absolutely. So, a lot of time, well, sometimes, examiners complain that affidavits and declarations by inventors in particular opine about legal conclusions. When we're talking about a legal conclusion, we mean something like non-obviousness rather than something factual. However, affidavits and declarations are a procedural mechanism, and they exist as a apparatus for submitting factual evidence to examiners to traverse rejections. Opinion testimony is entitled to consideration and weight, but only if the opinion is not on the ultimate legal conclusion at issue. And this is discussed in MPEP 716.01(c)(3). So an inventor can file a declaration on evidence for the examiner's consideration, but cannot conclude, for example, that a prima facie case of obviousness has been rebutted by unexpected results. So the question, Devang, is, have you ever seen this problem before?
Yeah, all the time. So especially in the area I used to examine in, pharmaceuticals and biotechnology, applicants often submit declarations to try and overcome obviousness rejections. It's very common. And sometimes they submit data. That's, in my opinion, and from what I saw, that was the most convincing, to actually get data. But sometimes we get opinion, and we then tend to take the opinion with a grain of salt because, of course, the inventor is going to come and give us the opinion that his invention is great. But yeah, we know that opinions submitted by the inventor or by non-legal people are supposed to be about facts and not making judgments on law. So it's okay if an inventor comes in and says, no, your prior art reference doesn't actually say that. No, your prior art reference doesn't actually teach that range, because that is a fact. But if the inventor comes in and says, well, no, actually, I don't think that this is obvious because of some reason, then that's not okay, because obviousness is a legal determination.
And so I guess the question is for, in the context of unexpected results, sometimes results are better, and that might not be expected, but that still isn't enough to be to create what in patent terms is unexpected results.
It depends. I think it's so unexpected results are what's called secondary considerations, right? So if something's obvious, it can still be patented if there's some secondary consideration that overcomes the obviousness. And so for unexpected results, so the secondary considerations have to be weighed, right, against the how obvious it is. And so unexpected results won't automatically overcome obviousness, but they can, depending on the magnitude, for example, of the unexpected results or the kind of the unexpected results. It's possible, and actually frequently in pharmaceuticals and biotechnology, frequently unexpected results are what's used to overcome obviousness.
Cool, great.
はい、ここまで、発明者が提出する、戦績供述書やデクラレーションの問題点について解説いただきました。次に、これに対して代理人はどうすべきかについて解説いただきたいと思います。So, Brian-san, these inventors probably are not fighting these declarations on their own. Shouldn't someone know the relevant law?
Yeah, of course. The attorney should know.
Yes.
So, examiners sometimes complain that patent attorneys and agents appear not to know the law. So, for example, they improperly permit inventors to file declarations and affidavits in which they opine on the law. That's basically what we were just discussing, right, Devang?
Exactly. Yeah.
Okay. Yeah. And in addition, outside of just the context of affidavits and declarations, attorneys also sometimes improperly submit teaching away arguments. Is that something you saw a lot of?
Yeah, but when I see it, yeah, but it's not necessarily that they're improperly submitting. Usually what I would see is that it wasn't actually teaching away. So the idea is, right, teaching away is when the examiner tries to combine two references together, or the teachings of two references together, to arrive at a finding of obviousness. Now, when sometimes it might actually be that there's something in one of those references, or maybe something of knowledge to one of ordinary skill in the art, that would actually make them not combine those references together. For example, suppose that I have some kind of a drink, sports drink composition, and then suppose that the claim limitation that I'm trying to get to as an examiner in rejecting it is maybe to make it red. And so I go out and I find the prior art that says, oh yeah, here's a red color. And then I say, okay, I can combine this together. And I put the red color with the sports drink.
Sure.
But what if you know that actually that chemical that gives the red color tastes really, really, really bad, or even worse, it's poisonous? In that case, actually, that would be kind of a teaching away from combining the references together, because you would not be, if the second reference says, hey, this is poisonous, don't drink it, then that's actually a teaching away from putting it into a drink. And so sometimes when that happens, then it's okay. That is teaching away. But sometimes there won't actually really be a teaching away. Sometimes it just will be that the second reference might teach other embodiments or teach other things that you can do. And then the patent attorney will try to say, oh, well, see, they're not really saying to do it, so it's a teaching away. And then that usually doesn't fly with me.
Did you notice any, that's, so I think attorneys all over the world get that wrong.
Mm.
Did you see approximately the same rate of improper teaching away from, would you say, domestic applicants versus foreign applicants?
Yeah, I don't think that there was a specific, I think it was, because usually what it was is it's clear that it's not the applicant that's actually making those arguments. And usually those arguments will come up in the well, sometimes they do come up in the declarations. That's true. But usually they're made by those arguments are made by the attorneys in the attorney arguments. And honestly, sometimes I wonder if maybe some of the attorneys are looking at the prior art themselves and just telling the applicant what to say in the declaration. I don't know. But because usually, then it matches up, right? The attorney arguments and the declaration. But I think, yeah, I don't think I saw it like particularly happening with between, say, foreign applicants and domestic applicants. I think it happens in both cases all the time.
Yeah, exactly. I think that's right.
I mean, it's kind of it's confusing lack of motivation to combine with teaching away. And I think usually what they'll try to say is, oh, it's teaching away, when really what they mean is there's not enough of a motivation to combine. But because I think they think that maybe teaching away sounds stronger or something like that. I don't know.
Yeah, in private practice, you and I discussed this recently. We're not really taught to present motivation arguments. But for me, in the last, I don't know, about 2 years or so, I started presenting more of them, and I've been surprised at how often they're effective when I make them, which is not often. And I think maybe that's what I'm getting at is, it's, you don't want to teach a very junior patent agent, for example, to make those kinds of arguments, because ultimately they don't have much sway. But when someone's been doing it for a while and they can better articulate their arguments by that mechanism, then I think that it's a reasonable thing for attorneys to do. And I think you're right that a lot of times the issue is more of lack of motivation as opposed to a true teaching away.
Right. And
applicants get it wrong and they say it's teaching away. Let me, since you're on our show, how often would you, if an applicant presented an argument, for example, for lack of, so the facts of the argument support a lack of motivation. However, an applicant would instead present the argument as teaching away. How often would you consider, like, well, that's not really teaching away, but you've got a great lack of motivation to combine argument, and so therefore I will, withdraw the rejection based on the lack of motivation to combine?
I think it depends. I mean, if it's clear that there is just no lack of motivation to combine, I don't know. I mean, and it also depends on where in the prosecution it is, right? Like, you know, if someone were to make that argument on an incoming RCE when I have a lot more time available to, you know, to do another search and to do all this kind of stuff, then maybe, because, you know, obviously we want to have the strongest possible rejection, right? But it depends. Like, if they don't come out and actually, you know, it's easiest to just dismiss it, right? And be like, oh yeah, that, you know, that's not teaching away because, you know, this and that. And so, you know, but yeah, I guess it depends. It depends on the situation. I mean, you know, usually for me, you know, that kind of stuff, it doesn't happen that often, right? In terms of my prior art combination being off the mark.
But there are certainly times then, though, that you would say, you know, that the applicant's making the wrong argument on the right facts, but you're not going to make their argument for them, right? There are certainly times you're probably like, well, I'm not going to worry about whether they had a better argument. I'm just going to maintain.
I don't know, honestly. Really? Yeah, I don't. Yeah, I don't know.
You're also pretty atypical, though, as an examiner, right?
Yeah, I mean, you know, I'm 13-0 at the board, right? I mean, I've never met another examiner that has 100% affirmation record. So yeah, and my rejections are good.
You retired flawlessly.
Flawless victory.
Okay. All right, so let's go ahead and move on. So, you know, what should attorneys do to address this issue? So, of course, they should learn the law. You know, in addition to reading court decisions and keeping up with, you know, certain blogs, you know, I would also check citations to even to cases that we already know, because our own professional understanding develops over time. And in particular, yeah, there are also new developments. So, for example, you know, on the predictable arcs, but I guess also on the unpredictable with you, you know, we have all this 101 guidance, the subject matter eligibility guidance that keeps changing.
Right.
It's now been incorporated into the MPEP, and you know, the MPEP was updated in June of last year, and so there are some pretty big changes that, you know, if you haven't checked on it in the last 6 months or so, I guess 7 or 8 now, you know, it might be quite a surprise.
Yeah, I agree. I mean, you know, I think sometimes, especially, you get some of the really old practitioners, you know, with the really low registration numbers. And you know, I've had some great ones, and that I've loved working with. And honestly, I consider them, you know, when I have interviews, I love soaking up the history. You know, I think I had a guy once who actually, I think he'd had an examiner interview when the office was still in Washington, D.C. or something.
Wow.
Like, I don't know. Like, I mean, like, you know, we're talking
old post office.
Right. Like some pretty ancient people. But, you know, it's great to hear about the history of the profession. But at the same time, you know, some of these guys don't know KSR. You know, some of them don't know a lot of the recent things. So they'll come at you with arguments. They'll be citing all their case law is like their newest case law is from like 1985. And, you know, and then you're like, that's not really, you know, how it works. Like, I had a one case where it was you know, an in-house counsel for a company, and you know, they had a case up on appeal, and you know, their whole point was because it was a very obvious solution, right? And so their whole thing was that they had discovered the problem, right? And so because they discovered the problem, then you know, their solution to the problem should be patentable. And you know, they tried to back it up with a lot of case law, but you know, the fact is that, you know, like for a composition, like in this case, you know, it's not necessary for the prior art to have the same motivation as applicant in doing what was done. I mean, yes, you know, we can weigh that them finding the problem, a new problem, as maybe something to be weighed in considering obviousness, but that's not, dispositive of obviousness, and it doesn't, or non-obviousness, and it doesn't make something that you did not obvious just because, you discovered a new problem, but then you did something that is already exactly taught in the prior art to solve it. But they kept on making that argument over and over again. And then I was affirmed at the board, right, as always. And then they came back with a response and made the same arguments over again. So then I had to, send in an office action out saying, hey, look, like, you already made these arguments. I already found them not persuasive. The board already, affirmed me and rejected these arguments too. Like, why do you continue with this? So yeah, it's out there. So yeah, I think knowing the law, and the other thing is that, it depends on the attorney, but some attorneys love citing case law. And most often I feel like it's kind of like form paragraphs, maybe, like that. Oh, there's a situation. Okay, cut and paste this thing here, and then this is the case law that applies. Not saying. I mean, I think sometimes the MPP is kind of like that too, right? I mean, you go to the section of the MPP, and it lists some case law and some findings from the case law. But the problem is that the people come in, cite the case law, but they don't really analyze the facts to see if it matches up, to see if the case law is really on point. And so the problem is that there are examiners who, don't know the law so much, which is normal because, right, that's not, to be an examiner, it's more important to understand the technology, right? And then, we get some legal training, and then you get what you need from the MPP too. And those kind of examiners will usually just entirely, ignore whatever case law you're throwing out and focus on the facts and what's in the MPP, because they know, like, that's not really like digging deep into the case law is not necessarily their thing. And then the other patent examiners who actually understand case law, which there actually are a lot of, then they'll actually look and be like, actually, no, the facts are different from that case you're citing, or this, this doesn't work. So, for me, whenever I get, almost every single time I've ever had an applicant try to cite case law in an appeal brief, for example, I just go into it and show them why their case law is not on point and why it doesn't line up on the facts in every single examiner's answer I've ever done. And sometimes it's really like, and half the time, actually, the case law that they're applying is better for my facts than for their, or better for my, it's more supportive of my rejection or my position than it is of theirs. So most of the time I'm able to turn the case law on them in the examiner's answer and say, no, the facts that we have in this case actually line up the other way. And the case law that you cited actually supports my rejection, not your appeal. And so, yeah, I think it's important to know these things. Sorry to go on.
No, it's fine. My only comment is, I'm sorry we couldn't get you here last session. That's very much, what our topics were back then.
Hi. Thank you. So attorneys should learn and relearn the law to constantly improve their advocacy.
That's a very good summary. Yeah, I agree. I would love to see that. I love seeing great arguments from attorneys. It's always like, wow. And when an attorney actually does come and apply the case law right, then yeah, I really love to see that kind of stuff. As if you're a good examiner, you want to grant patents, I think. Anyway.
Okay, thank you.
Well, great. Thank you so much for joining us, Devon. I really appreciate it.
Anytime.
Thank you. はい。今回はこれで以上になります。ご質問や扱ってほしいトピックなどがありましたら、YouTube のコメント欄に書いていただくか、スライド最後に記載のメールアドレスまでお気軽にご連絡ください。日本語でも英語でも構いません。では本日もありがとうございました。失礼します。